following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the intricacies of the latest updates surrounding the judicial independence of Sri Lanka. How do certain legislature affect the independence of Sri Lanka's judiciary? A very good evening and thank you for taking the time to join us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now, today's topic is something that goes in tandem with one of our recent, most previous episodes, and that's on judicial independence. Now, I'm aware that we've done multiple programs relating to the judiciary, but really with recent judgments coming about and new bills that we've seen in discussion, judicial independence has really come into question. And to speak about the specifics of judicial independence and the nitty-gritties, we have someone that's not a new face on the show, and that is Mr. Krisantha Nissanka, attorney at law. Thank you very much, sir, for taking the time once again to enlighten our viewers on yet another topic that I believe would be beneficial for us to learn about. Thank you, sir.
Thank you.
A little bit of a breakdown before we get into the discussion. We'll be going into the basics first when it comes to the salient features of judicial independence, what exactly it is and its history. Next, we'll be going into the current context with recent judgments coming about. And finally, we'll be talking about potential issues that are faced by judicial independence in Sri Lanka. Well, without any further ado, let's get right into this discussion. Once again, sir, thank you. We have quite a bit to break down as well, not just relating to recent judgments, but also relating to the history of it all. So I think it's best if we start at the very roots. If you could, sir, give us a little bit of an understanding about the actual principle of judicial independence and how it has evolved over history in Sri Lanka.
Well, this particular word, judicial, is a deep-rooted principle in the history of this country, because though the British used this word judicial independence, long before British came into this country, people knew the meaning of judicial, that is adhikarana. This is something embedded in the Buddhist philosophy, Tripitaka, and there were places where this particular judicial activity took place, and the people knew it very well. So the word, this is a special kind of a thing, that is what the word means, the special way of solving a dispute or making about a decision. So that is adhikarana, which was very well known to the people, these people of the country, long before the British came into this country. So when you discuss it, we have to look at it from the point of view of the people of this country, because it's the people who have enacted all laws. So people engaged in making law from the very outset, because in the history it said that there was the principle, the basic underlying principle behind judiciary was that they should abide by the Buddhist principles. If there is to be justice, this particular word should have that meaning, that context should be taken into consideration. So justice in Sinhala is called dharmishta, that is, it should be according to dharma. So the adhikarana or the judicial practices also should be taken in that context. So independence, when it comes to independence, so we depended on those principles, and because of the Portuguese, the Dutch and the English, they took over the maritime provinces, those areas were governed by them for a very long period, 500 years. So during that period, the judiciary acted according to the principles, foreign laws, say the Roman Dutch law, the Portuguese law and Roman law, or whatever it is, English law, and so on. But now the situation has changed. Now we are an independent state once again. So when the country becomes independent, the judiciary also should become independent. In that sense, what is the legal system we should revert to? And that is the issue. We should have an independent legal system. More than the salaries of the judges, more than the interference by the legislature into the judiciary, executive approaches towards the judiciary, more than that, the basic principle lies the independence of the legal system. So that is my focus on legal judicial independence.
Right. That is the history and also the fundamental basis of judicial independence and what judicial independence ought to be. It's not just some sort of term that we have to throw around, but it's something that is ingrained in the democracy of this country, essentially. I think now that we have a bit of a past context, I would say, relating to judicial independence, it's important for us to actually discuss the present as well. When it comes to judicial independence and also the structure of judiciary, so I think if we can get a little bit of insight into how the balance of power occurs there and also how the judiciary actually maintains its independence recently.
We'll take the first part of it. Now, the Constitution very clearly states that the principle is basically, Article 4 of the Constitution very clearly states that the judicial power of the people shall be exercised by Parliament through courts. So, it is the judicial power of the people. So that will be exercised by Parliament through courts, tribunals and institutions created and established or recognized by the Constitution or created and established by law, except in regard to matters relating to the privileges, immunities and powers of the Parliament and its members, wherein the judicial power of the people may be exercised directly by Parliament according to law when it comes to privileges. So the basic principle is that it is the power of the people. So the judicial power rests in the people of this country. Now, when we became independent from the British, I would like to ask the people of this country, what is the legal system we should revert back to? Called reverse engineering process should take place. That is, we should get back to the earlier position where we was. You know, Anuradhi, regarding this matter, the Kandyan Convention, 1815 Kandyan Convention, plays a major role, because there, even during the British period, we made our judicial system prevalent with the British even. How was that? This particular Article 5 of the Covenant, Kandyan Convention, the British had to adhere to those principles in this country. So, now when you talk of independence of a judicial system, even with the perpetrator, conqueror, we have maintained our judicial system within their system. And they recognize this judicial methodology or people's right to engage their religious beliefs. I don't call it, Buddhism is not a religion in a particular sense, it's a way of life. It's a separate legal system. So this had a place in the judicial system. So the word independent should be very carefully used, because we were independent to a particular extent. So I hope that is the most important thing. And in 1978 Constitution, especially in 1972 we got rid of the British Empire, and now in 1978 we were very specific by introducing the word Buddha Sasana into the Constitution. So that included a specific jurisprudential thought into the system through words. It was there, but this particular word was inserted once again. So after a lack of, after 100 years of, mostly 100 years, we were able to bring back this particular word into the system. And that is, we brought back the earlier judicial system where it introduced a special duty. But that duty is what the people wanted the judiciary, the legislature and the executive to perform. Very recently, the president of the country declared it and said that all three organs should abide by this duty. So that is the background of, this is how you should interpret judicial independence, because that is the judicial system people wanted to have in this country. And it should not be interfered by external forces.
There should be some sort of lens through which that we view judicial independence, in which it is not compromised by other factors, is what I'm understanding from this conversation. Sir, I think building on this fact, you just mentioned that recently the President also has addressed the independence that should be allowed towards all three branches in order to carry out an effective state. When it comes to recent judgments that we have seen, specifically we saw some during the pandemic as well, that may or may not actually play into the dangers posed to the independence of our judiciary. Could you please explain to us how exactly we navigated that as a country?
Now, during the COVID, that particular bill was named COVID-19. It was a special bill which was brought before the Parliament for the purpose of bringing about foreign law into the country, because there was an issue regarding the COVID pandemic, and people were not allowed to go out of the country without the vaccination and the rest, which was prescribed by the World Health Organization. Now there was a problem. That is, international law played a role at that particular juncture. But, Anuradhi, the judiciary of this country didn't get into that pitfall. They said, especially in this COVID-19 determination matter, a lawyer actually took the responsibility and did his presentations with the Supreme Court and emphasized that even under those circumstances, we should not get foreign law into the country. And that was accepted by the Supreme Court. Actually, by that decision, the determination, I should call it the determination, we maintained our judicial independence. So that was a fine incident where we saw foreign law. I mean, it's true that we use English law, Roman Dutch law, but within the purview of the Constitution, not beyond that. So that we have preserved up to date.
Exactly. And a question of curiosity to follow up on that, sir.
Yes.
When it comes to the involvement of foreign laws and foreign legislature in the Sri Lankan context, how exactly does that play into Sri Lanka's sovereignty and also Sri Lanka's independence? Because considering dualism and monism as well, we see certain issues when it comes to entrenching certain legislatures that are not organically created. Could you walk us through the intricacies of actually maintaining our sovereignty in relation to certain legal suggestions that may pop up in the international sphere?
Now, most of our people have gone to the UN on certain matters, especially regarding the fundamental rights issue. Now, I have my reservation on this fundamental rights issue. All the fundamental rights other than Article 10 are subject to certain conditions. That is called the right-based jurisprudence. Whereas, I'm deviating a little because I have to explain this matter to you, Anuradhi. The Article 9 very clearly states a duty-based jurisprudence. So, people talk of these fundamental rights. For me, it's foreign. This is a novel idea which I am bringing about. For me, fundamental rights is a foreign thing, though we have it in the Constitution. Even those rights are subject to certain limitations. Now, regarding duties, if you go to the Constitution, you will see under Chapter 6, you get this directive principles of state policy and fundamental duties. But unfortunately, the said fundamental duties cannot be performed properly because of a particular section. Under Article 29, it says, the provisions of this chapter do not confer or impose legal rights or obligations and are not enforceable in any court or tribunal. No question of inconsistency with such provisions shall be raised in any court or tribunal. So what happens? The duties cannot be enforced in a court of law. But, Anuradhi, under Article 9 also there is a duty, right? So this duty has no limitations. So the only duty to be looked after by all three organs of the state is to preserve this duty. So the legal duty also comes from this Article 9 duty, where it says, the Republic of Sri Lanka shall give to Buddhism the foremost place, and accordingly it shall be the duty of the state to protect and foster Buddha Sasana. So, the fundamental rights thing, beyond the fundamental rights thing, this is a duty-based jurisprudence, and it is the duty-based jurisprudence which governs the whole area of judicial independence.
Exactly. That's a very key important fact to actually note, because of the fact that the very fundamentals of the two systems are different. Therefore, there's a problem with cohesiveness as well when bringing in foreign legislature into the local context, even as you have just mentioned as well, sir. Unfortunately, our time has run up in this certain segment. We do have to specifically talk about a lot of the current context and the recent developments as well. But before we get into any of that, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back. Welcome back to Law, Land and Liberty. We're in discussion with Mr. Krisantha Nissanka, attorney at law. So we just embarked on a very momentous segment where we spoke about the basics of judicial independence, I believe, and the history leading up to it. But we are in the midst of actually discussing the current context. And I believe I had to unfortunately interrupt you when speaking about the fundamental differences that there lies between the systems that are in place in order to maintain judicial independence in certain parts of the world, and we are fundamentally different, specifically in relation to a specific article in our constitution, the Article 9, and how that actually gives power to multiple other, actually the functionality of the constitution in itself. If you could help us delve a little bit deeper into exactly why foreign law, it's not just the fact that it might undermine our sovereignty, but there is also a lasting impact on why exactly we cannot allow a floodgate scenario to happen.
The basic reason is, as I said earlier, the right and duty-based system. Now, most of the judicial systems in the world are based on a particular religious concept, whether we like it or not. Each legal system has its own roots in religions. So when it comes to law, we have to understand the truth, that we have to find out the deep-rooted principles behind the law. So the word religion comes from the Latin religata, that is the relationship between man and the God. So most of the judicial systems have based their jurisprudence on the concept of God, whereas our system of jurisprudence is not based on omnipotent God or principles of that caliber. We depend ourselves, we are independent even in thought, because we are not dependent upon a God. So our legal system differs from most of those systems. So the way people think, law is a product of the people, in the minds of the people. So when you compare the two legal systems, you will find that one legal system says something about God, and the other legal system talks of something else. No God principle. So this Buddha Sasana principle doesn't belong to the God-oriented jurisprudence. So there is a difference, and that is why we have to see the core of the matter and find out why the foreign judgments don't tally with ours. So when choosing foreign laws, when you go for treaties and agreements with foreign countries, we have to be very careful to see that that we should not tamper into those areas where there would be a conflict. And that is the major issue. The jurisprudence, the jurisprudential issue, and now the executive and the parliament, most of the time, if they don't consider this, they will just sign agreements and treaties, and they will get into trouble. So that is an area where we have to be very careful. People will have to be very vigilant about, to see whether our executive and our parliament acts according to the constitution, where in Article 157 there is a special situation where the parliament is allowed to get into international law. It says, it discusses about international treaties and agreements. In Article 157, where Parliament by resolution passed by not less than 2/3 of the whole number of members of Parliament voting in its favour, approves as being essential for the development of the national economy. That is the only area where you can go for a treaty with other countries. So, now when you get into a treaty or agreement between the government of Sri Lanka and the government of any foreign state for the promotion and protection of the investments in Sri Lanka of such foreign state, still there are limitations to that even. So that is what we have been discussing about the recent developments on this line.
Exactly. I think that's a perfect segue for us to actually discuss the recent developments. Are there any specific judicial rulings that we can take of note as the general public to be informed about in relation to this area, sir?
Yes. There was a case called Singharaja, where the LTT suspect went into the international courts, and we have entered into a treaty on this issue, but Sri Lanka made representations to the international court and said we are not bound by international law, because the reason was that the protocol signed by the president on that matter was not approved by the people. So the domestic approval is a must. That is why I said it is the people's wish. This is not a parliamentary system we have. Today we have a country where the people can initiate laws. As we have discussed earlier, I hope you remember, Article 85 subsection 2 very clearly states that people are in a position to initiate laws, and they can go against the decision of a parliament even. So when it comes to international treaties, people have not allowed either the parliament or the executive nor the judiciary. So the judiciary has to abide by these principles laid down by the people in the constitution.
Exactly. And that, I think, brings me to yet another question that I can build on, specifically in relation to the part that the public play when it comes to judicial independence. If you could, sir, walk us through how certain agencies that have been handed as rights to the public can be jeopardized if there is any way to entrench foreign laws in Sri Lankan legislature.
Yes. Now, there were certain incidences in the very recent past where there was a question whether foreign lawyers could come into this country, whether institutions of the UNO could have its officers to make judgments in Sri Lanka, and that type of questions arose. But they were refuted, and we are now in a sound position. We are still independent in that sense. So it's high time for people. And there is another issue, Anuradhi. Now, all these international covenants, they have a monopoly. That is the language aspect of it. All the international laws are either in English or Russian or basic 6 languages. What is our position? We should be in a position to know exactly what the international treaty is in Sinhala or Tamil. Those are the two judicial languages of the country. So now this issue, even the local laws are not in Sinhala. In a situation, in such a scenario, how could you say that people maintains its sovereignty, judicial sovereignty along with? That is a big issue.
And sir, a question of curiosity, when it comes to the language aspect specifically, we have always seen that the single text will prevail in all situations in relation to legislature specifically. If by chance there is foreign legislature that happens to be entrenched into Sri Lankan legislature and there's translation occurring, how exactly does that aspect play out for the primacy that a Sinhala text is given in relation to legislature, sir?
Well, legislature has no right to do anything in English, compulsorily, because Article 24 of the Constitution is very specific on this matter, because if the Sinhala text prevails, what does that mean? The initiating party's language becomes the law. The majority of people in this country do all their transactions in Sinhala. So when they create the law, it is the people who create the law. It's done in Sinhala. So the grundnorm, the basic principles of jurisprudence is created in a language which is very close to the people of this country. What is foreign to us comes through other languages. So language and foreign law are interrelated. So we have this is where I should call it language independence plays a major role in judicial independence.
We do have to speak about the specifics in relation to the development of international law alongside Sri Lanka's legal context and also future implications when it comes to recent judgments that we have seen and recent legislatures that have been proposed. But before we get into any of the specifics relating to these recent judgments, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back. Welcome back to Law, Land and Liberty. We're in our final segment with Mr. Krisantha Nissanka, Attorney at Law. Sir, I believe we got into a little bit of a contentious point in relation to the protection of judicial independence in Sri Lanka, and that's on the language aspect. And we were just speaking about how language independence does translate to judicial independence, hence even plays into sovereignty as well, specifically because Sri Lanka is not exactly a popular language globally, but English and other nations with large populations tend to have a monopoly over the actual preferred language in relation to legislature. I think it's important for us, before we get into the future implications of actually involving international and foreign legislatures in Sri Lanka, to talk about that language aspect a little bit more in relation to the fact that it has become a monopoly. So can you please walk us through why exactly this could prove to be fatal for the future of Sri Lanka's independence when it comes to not just language but also just democracy in itself?
Now, the recent developments in the intelligence of the people of the world is based on artificial intelligence. Now, it has a direct impact on our legal system. Why? Why do I say this? The reason is, Anuradhi, now even our children, when they want to study law, what they do is they go before the computer or the phone and use Chat GPT 3.5, 4 and so on. Now, when a question is put to Chat GPT on a legal issue, who answers those questions? It is the programmer behind that software, artificial intelligence. Now, the whole world is governed by one particular institution in that sense. The people who are in charge of that artificial intelligence provider has all his knowledge according to his or its whims and fancies. Now, as I said earlier, they are not conversant with our way of thinking. They do it in English. Basically, all the transactions are done in English. So they download or their input of stuff into the system is based on their thinking, their jurisprudence. Now, I have seen a particular development in this country also. Most of the lawyers, I hope the judges also, depend, because of the speed of the knowledge gathering process, they depend on the AI or ChatGPT. I don't know whether it's proper to say ChatGPT because there are so many other machines as well. But as a person who was engaged in this field for a long time, I have been using translating machines for a very long time. And what I have seen is, even a translation can be manipulated by outsider according to his interpretations. So, what about legal systems? So the answers which is given by the AI programs depend on the jurisprudence of the creator of that program. I think what you asked was this: whether that international monopoly would affect us. Yes, of course. So that is why I said, when you think of foreign invasion by way of language and jurisprudence would affect our system, that will affect definitely Article 9 of the Constitution.
Exactly. And a question of curiosity, sir, before we get into future aspects, which would be the final bit of this discussion, I'd like to ask you about the colonialism aspects as well. We touched on it very briefly in the beginning, in the first segment, but with recent judgments and recent bills being brought into the public sphere, we have seen a lot of talk relating to the actual origins of our judicial independence, and as you just rightly mentioned, where it truly lies. How exactly can Sri Lanka actually manage to navigate the confusion that has arisen relating to recent aspects of judicial independence and also the past in connection to colonialism?
First, we have to be in firm grounds. We should know what our identity is. Without that firm ground, we would not be in a position to fight the outsider, the conqueror. So we have enough legislation to that effect to safeguard ourselves. But there is a danger, and there are so many suggestions to change this constitution. Especially there are certain provisions in the constitution which we have to safeguard. That is the inviolable, that is Article 1 to 111, and Article 16. This is very important. I don't know whether you have time. Article 16 is very clear on this matter. It's a very simple article where it says, Article 16 says, 16.1 says, all existing written law and unwritten law shall be valid and operative, notwithstanding any inconsistency with the preceding provisions of this chapter. Now this is a very important thing, because our traditional jurisprudence, our customs and laws are embedded in this. Though most of them are explicit ones are in par with the English law and Roman Dutch law, a certain part of the jurisprudence is based on Article 9 and Viharadeva Gampanatha and all these other Buddhist principles. So most of the people are trying to get rid of Article 16, which is not an entrenched article according to Article 83 of the Constitution. So I want to bring it to the notice of the people that we have to study this Article 16, because it is very important with regard to judicial independence, because it plays a pivotal role in safeguarding judicial independence of this country.
Exactly. We as a people have to be knowledgeable about the articles and also the pieces of legislature that actually give Sri Lanka their judicial independence, and actually have an idea of what exactly that entails and the gravity of that situation. I believe, sir, we have to speak about any future implications that could arise with the current discussion that we see going along in relation to bringing in foreign law and foreign judgments into the Sri Lankan context. Could you please give us your take on the specific problems that could arise in the future?
Yes. Article 157A, that is a global issue where the foreign powers are breaking countries into two, separatism. Now this particular article is about prohibition against violation of territorial integrity of Sri Lanka. Now, before they enter into the territorial integrity of a country, what they do is, conquerors throughout history have been conquered by all, right, from Chola, Pandya, Kerala, then Chandrabanu from Malay, then Burma, China, Portuguese, Dutch, English, and even the French tried to conquer. There was an agreement between the French and the Sri Lankan government. So they tried to break this country into pieces, and they force us to accept certain laws. When they can't do it directly, they do it indirectly. So before the independence of the territory, there comes the issue of the people's integrity, that is, independence of the judiciary. They try to put into pieces. They try to fragment this legal system. That is a very dangerous one. But I should like to focus your attention on a specific sentence which is vital in this sense. No person shall directly or indirectly, in or outside Sri Lanka, support, espouse, promote, finance, encourage, or advocate the establishment of a separate state within the territory of Sri Lanka. So, trying to bring about a law also amounts to this independence issue, right? So, what they can shatter first is the legal system. Now, in this COVID-19 judgment, the Supreme Court was very clear on that and said no inroads should be allowed for foreign law to come into this country. So this is specific, and the result is also, if you try to do this, your civics liabilities would be taken off from you.
Exactly. So we have legislature and judgments that actually confirm that we shouldn't be allowing any sort of instability in our foundation as a country when relating not just to judicial independence but also the country's sovereignty in itself. And as you mentioned, no inroads must be allowed in order to maintain our territorial integrity and our national integrity as well. Unfortunately, sir, our time here today has come to an end. Thank you very much for taking the time to enlighten our viewers when it comes to the extremely complicated subject of judicial integrity and judicial independence. Thank you very much for your time, sir.
Thank you very much for inviting me for this wonderful program.
Well, it's important to remember that there is a key role that we play as citizens of Sri Lanka in making sure that there is no harm done to our already existing legal procedures, as it is our only means of having justice delivered aptly. We leave you tonight with the words of former US President Andrew Jackson. All the rights secured to the citizens under the Constitution are worth nothing and a mere bubble except guaranteed to them by an independent and virtuous judiciary. That is all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/OtherThanEnglish. Thank you very much for watching. Have a good night.